Okay, so the judiciary, and the main thing here is, I mean, some of the slides get into the basic mechanics of what the judicial system, how it's structured, the different levels, where things go, some of the details of the judges, and so on. In the first slide, the main point, lifetime tenure. So once you're appointed to the federal judiciary, it's different in some states, at the state courts, but the federal courts, once you're appointed to a federal judgeship, you have that for life. Okay, so you never have to run for re-election, and you never have to run for election to begin with. Uh, Federal judges are appointed by the president, but they have to be confirmed by the Senate. So again, separation of powers. No one branch has control over the other branch. Both the executive and the legislative have to work together to appoint judges to the federal bench. But then once the judges are there, they have lifetime tenure with good behavior. They have to do something really terrible to be removed from office. So there are no elections. So they're basically, and they're in charge of judicial review, which again is the power of the courts to review the acts of other branches of government and the state. So they can review executive orders, laws passed by Congress, signed into law by the president, and state laws. They can review all of those things and say, are they constitutional or not? And if the Supreme Court or if the federal courts decide that these are unconstitutional, they can be struck down. Okay, and so federal judges have this ability, but they're not subject to any democratic controls. This is intentionally anti-democratic. As you remember from the discussion of the Judiciary in the Federalist Papers, that earlier lecture, this was done on purpose. This was done intentionally. The idea was you want judges to be able to focus on interpreting the law, interpreting the Constitution, and applying it, and not worrying about political pressure. Not worrying about being reelected, not worrying about keeping Congress happy or the president happy, not worrying about anything other than focusing on the law itself. So there's an independent judiciary. Again, some states it's different. Judges run for election, re-election, but at the federal level, judges are appointed and then they have lifetime tenure. The idea is basically, again, it's intentionally undemocratic or anti-democratic. Okay, and again, this is all intentional. And again, think about Brown v. Board of Education, 1954, the ruling that said segregation is unconstitutional. Imagine that the Supreme Court or half the Supreme Court had to run for election then in 1956. They wouldn't have done very well in the southern states. They may not have done very well. And of course, there would be other issues that may make the current court unpopular. And that's exactly what the founders didn't want. They didn't want a situation where Supreme Court justices are being thrown out of office, voted out of office, because they've made unpopular decisions, and therefore the interpretation of the Constitution is changing every 4 years or every 10 years or whatever because of elections. They wanted an independent judiciary, and that's the way that it's set up. Now, that being said, if a Supreme Court decision is that unpopular, the Constitution can, of course, be amended through democratic means. So although the federal courts are undemocratic, and that's by design, there is still ultimately a democratic authority over the courts, namely the amendment process. The Constitution can be amended by Congress and the state governments. It's very difficult, but it can be done. So it's not as if the final say and the final control over the Constitution, so to speak, is in undemocratic hands. Ultimately, if there's enough concern or enough popular will to change the Constitution, it can be done through the amendment process. So the judicial review controlled by the courts, which are undemocratic. However, again, ultimately the Constitution can be changed through democratic means, namely through a constitutional amendment, which again requires both Congress and 3/4 of state governments to agree, or of course 3/4 of these state conventions, if they go that route, to agree to that. Okay, then the difference between different types of law. Adversarial system, the idea is that in the American system, you have an adversarial system where both sides are kind of trying to represent their client. Both lawyers are trying to represent their client as zealously as possible, as energetically as possible. They're not really worried. I mean, they're not totally amoral, but they're not really worried about, do I think this guy is really guilty, or do I think my client really is at fault here? They want to represent their client as zealously as possible, and the idea is that the judge is impartial or neutral, and this is how truth will emerge, through an adversarial system where two lawyers are sort of arguing back and forth, representing their clients as zealously or as energetically as they possibly can. That's the theory. In reality, most cases are actually settled out of court, so it doesn't always happen. But again, the reason that it's set up, the adversarial system, the way that it is because of the idea that this conflict will produce truth. Okay, then or a correct legal decision. Then the final slide: how do political scientists explain judicial decision making? So a case goes before a federal court or before the Supreme Court. The Supreme Court makes a decision. What do people say is actually happening there? What's the actual influence? How do Supreme Court justices make these decisions? And there are three major theories here on the slide. The first is behavioral. That says that actually, really it's about personality. It's about the background of the justices. It's about their religious beliefs. So, Antonin Scalia, a very conservative judge, very intelligent judge on the Supreme Court, this argument, the behavioral argument or the behavioralist argument, is that when a court case involving abortion comes before the court, Antonin Scalia, because of his religious beliefs, feels a certain way about abortion, because of his background, because of his religious beliefs. For basically non-rational reasons, he thinks abortion is wrong. So he wants to rule against abortion. But he feels that for basically non-legal, even non-rational reasons, and then he comes up with legal reasons to justify that belief. Okay, so that's the behavioral model of how judges make decisions, that they make decisions really based on personality, on background, on religious belief, based on these kind of personal, not really legal, not really rational attitudes or kind of aspects of their personality that they have. They make these decisions about court cases, and then they use their legal training to justify it. There's the attitudinal model, which basically says, well, it's not quite that irrational, but justices really are motivated by their political and policy views. So if they think that low taxes are good, or if they think that their attitude towards the First Amendment, for instance, is not based on purely legal grounds, it's based on their policy and their political views. If they think that campaign finance reform or campaign finance restrictions are good, that will determine how they rule in First Amendment cases involving campaign finance, not so much this sort of strict legal reading that they might give. And then finally, there's the strategic model, which basically says judges are very strategic. They're aware of how a court decision might be made. So if there are 9 Supreme Court justices, as an earlier slide explains, if one of them 4 of them have to decide in order to rule on it, in order to actually hear a case. If justices think that their side would lose, then they'll vote against hearing the case. And they might also be strategic about the larger public perceptions of the court, and they might make decisions based on that to some extent. So that idea is, well, they're strategic in their thinking. They think, what is going to happen if we hear this case, and even if they get to the point of hearing a case, they think, what is going to happen if we decide this way or that way? How is that going to affect public perceptions of the Supreme Court, of the court system in general? How is it going to affect public perceptions of the legitimacy of the court system, and so on? So they're sort of, again, they're not simply looking at legal questions. They're looking at a larger political and social picture and saying, strategically, what is the right thing to do here? How should we make these decisions, and so on? Okay, so obviously these three kind of downplay the actual role of legal reasoning, which of course was the whole justification of the Federalist Papers to begin with, is that the justices should focus solely on, again, legal reasoning. They shouldn't be motivated by these other things. These are 3 other theories that say, well, legal reasoning is there, but it's not all that is there. There are other things motivating Supreme Court justices. There are other influences. There are other things that they're aware of besides simply legal arguments. So, in a way, you could throw in a 4th model, which says, well, it's really just about their legal opinions, their legal training, their legal philosophy. But these models of judicial decision making all emphasize different things, other things that basically might influence judges beyond just their judicial philosophy or their legal training or beliefs.